Hi, this is Marc Stewart again, here to talk about medical malpractice lawsuits. My clients, when they first meet with me, they have a lot of questions, obviously. They want to explain what happened to them and they want to talk about the process. One of the things about the process that most people don't realize is how the life of a medical malpractice case really works in real life. It's sort of a practical reality thing, a nitty-gritty thing. So I thought I would do a little video and talk about that. When my clients first come to me, sometimes we talk on the phone, sometimes we meet in person, just depends on how far away they are. They may bring their wife, they may bring their spouse, they may bring their entire family, just depends. We go over everything. Maybe there's paperwork to sign, like medical authorizations and contracts and things like that. My clients often have to fill in the blanks so that my staff can make a file on them and make a place in our filing cabinets for them. Then we order medical records. Sometimes our clients have the medical records already, sometimes they don't. Sometimes we have to get them. And sometimes that process can take a couple of months, maybe more, just depending on how many facilities there are and where we have to order them from, how many doctors, etc. Once we get the records in, then I review them. My staff may review them. We will go through them. We'll usually digitize them, put them in the computer, put them in a PDF, Adobe Acrobat. We may OCR them so that we can search them easier. I'll usually develop some sort of a timeline, a chronology. Many times I can tell if we have a case, a good, valid, actionable case at that point. Sometimes I need to first contact a medical expert. I'll talk to whatever medical doctor or nurse that may have special knowledge relevant to my client's specific case. Then we'll get an opinion from them. That may take another month or two to get the doctor's attention, to find the right expert, to send the stuff to them, to have them make time to review everything and then report their findings back to them. Sometimes we have them draft written reports, affidavits, a summary of their opinions. Once that's done, I usually meet with the client again and we talk about what I found. At that stage, sometimes I end up declining the case because I don't think I can successfully pursue it. Sometimes we take the case and I say, let's go. And my client says, great. And usually what that means is we file a lawsuit next. A lawsuit is filed in the county where the negligence happened, usually. We'll talk about venue rules in another video. Once the lawsuit's filed, the defense, however many defendants there may be, they have about 30 days, sometimes 20, just depends on the jurisdiction, to file an answer in the court. That's just a few pieces of paper basically acknowledging that the suit's been filed. Maybe they assert some basic defenses. We usually know at that point who their attorney is going to be. Usually that attorney is somebody that I've worked with before, have some sort of working relationship with. It's a small community of medical malpractice lawyers in most states. At that point, then we begin the process of discovery. That's where we share documents with the other side, maybe medical records or other documents. We ask for records, they ask for records, and we go back and forth. There are medical authorizations that have to be signed in favor of the defense so that they can get my client's records and start their own investigation. That process takes a few months. Then, usually the next step is depositions, and that would be my clients giving their depositions first, a process we may talk about in another video. Nothing to be scared about. I will prepare you for that sort of thing. Then, shortly after that, I will take the depositions of the defendant or the defendants. At that stage, there may be a conversation about settlement, maybe not. The next step is usually to take the depositions of my experts, and then we depose the defense experts. Sometime in there may be an opportunity to attend a mediation with an independent mediator in a voluntary effort to try to settle the case. Some jurisdictions require that, some courts do not. Sometimes there's no voluntary decision to do that. Maybe the defense doesn't want to settle at that point. Anyway, eventually there will be a trial. Now, when the trial is set, it's usually set fairly on by the court in the process, but every county and every court can be different. Usually the trial setting is at least a year out from the date that we file the lawsuit. Sometimes it's more like 2 years, could be 3 years. Every county has a different docket, a burden of cases that they've got to work through. Some counties and rural places don't try that many lawsuits, so making their calendars more complicated for a big, crazy, complicated medical malpractice case. Anyway, the life of a medical malpractice case can live for usually a year to maybe 3 years, and that assumes that no appeal happens after a successful verdict at trial. So The trial in the case is usually about a week, but they can be longer. It just depends, again, on the nature of the case and the facts. Anyway, I hope this has been helpful or informative in some way. If you have any more questions, feel free to email me. You'll see it at the end of the video. Thanks.